Good afternoon, ladies and gentlemen. It is now 5 o'clock, and welcome to the last webinar for medical law. I'm going to share my screen. I hope you can all see it. Let me just do that. Yeah. So if you can't, please tell me you cannot see it so that I can make a plan. Okay, so as I've said, today is the third webinar, the last part of your medical law um, course that you did. And you know by now your lecturers that I am Professor Martha Slabbert and your facilitator is Bonnie Venter. So tonight is going to be a little bit slower than the previous ones. So there's not so much to cover today. But remember, for all your administrative matters, you will have to contact Grace and she will assist. We had two previous webinars. The first one basically on the Constitution and medical law, the second one on medical negligence per se. And then today we're doing the last part. The webinars, although they are recorded, they are not provided to you as students. That is a decision from LEAD and not from my part, but the slides will be made available. So once again, tonight when I'm done, I will send the slides, the PowerPoint, and Bonnie and Grace will upload it on your website. And then if you've got any questions, there's my email again. You are welcome to ask me. If I can't help you, maybe I can just direct you into a certain direction. But yes, just remember that I'm not in practice, so I cannot solve matters for you. I can just give you pointers to think about. Then you will see in your study material, there were some practical exercises. We are not going to provide the model answers for these exercises, as every case differs and every attorney or advocate will also approach a case differently. So we do not provide the model answers. We just give it to you so that you can see more or less what a case will look like. Just a few general matters. See the announcements regularly or the extra material that Bonnie uploads on your websites. And then your portfolios. I've seen the marks for portfolio 1 and I am very, very, very impressed and congratulations to all of you. I think you all did very well. And now it is only the last portfolio and then you are done. So please do not give up now. Even if you feel tired like the picture you see, do not give up. Ask us if something happens so that we can look at your case individually and either grant you extension or help you where we can. And then you see there that I have said questions. So I thought today I'm going to change a little bit and I'm going to switch on my camera now so that you can see me. And I would like to know whether you have questions. Do you have questions? Anyone, put up your hand whether you have questions on the work that we've done until now. Or do you have comments to make? Or do you have problems with your portfolios? Anything. So you can just put up your hand or just unmute yourself and then you can speak to me. Not one with a comment. Can you hear me?
Hi, good afternoon. Can you hear me?
Yes, I can hear you. At least one. Yes. Do you have a question, a comment?
Yeah, thank you. I think it's quite an involved, short program. I thought it would be a walk in the park, but it turned out to be quite one that requires more time. But that said, I've been enjoying it. So, the only thing that is left that I haven't attended to is the test. And I wanted to understand how that works.
Okay, test one.
Is it the only
Is
test?
that
Yes.
test one?
Well, I haven't done any tests. I've just been working on portfolio. So I now need to shift my focus to the tests. And is it only test one that matters that we need to work on, or is there any more that it's expected?
No, there's only a test one. A test one, it opened on a certain day and it closed on a certain day. I am not 100% can't remember the date, but please email Grace as soon as possible to make sure when test one closes. It's a multiple choice question paper. I just want to ask Puku, Mapengua, just switch off your cameras. Please, people, just switch off your cameras. I've just switched on mine because I want to speak to you, but for the data for the other students, right at the top in the right hand, you will see camera and mic. So just switch off your camera. But okay, to come back to test one, please urgently contact Grace and ask when is the last day for submitting test one. You must go through all the theory in the study guide. In other words, the portfolios or the activities are not relevant to test one. Only the theory as it is provided under the different headings in your study material. You must go through that, and once you feel confident that you feel you know the work, then you go onto your website and you do test one. It's multiple choice, so it will open and it will give you a certain time and you have to choose the correct answers. And that test one is quite important because it is 20% of your final mark. So you will do the questions and you will get a mark, and that mark will contribute 20% of your final mark. Then you, at the end, you would have done six portfolios, 3 in portfolio 1, 4, 5, and 6 in portfolio 2. Those marks will be worked out of 80. And then the 80 and the 20 will be counted together, and that will be your final mark. So yes, there's only one test. There's only one test, but there are 6 activities. And the 6 activities are divided into 2 portfolios. So I'm just not sure. I had the date last time, but I forgot. So you must just find out from Grace when does it close, test one. Then I see Wada Magwape, you have a hand. You can speak. Just unmute yourself.
Good evening, Prof.
Evening.
I just wanted to find out, the quizzes also on the platform, so are those also not compulsory? Because I hear you say only the portfolios and the tests are relevant.
Which questions in the study material?
Each topic has a quiz of some sort. I don't know if those.
Okay. Test one, you have to open. You have to open. So it is not part of your study material. Your study material is the theory. It is the theory. It is, sorry?
Not test one, Prof. There are quizzes. I don't know if you open the tab of test quizzes. Yes.
Yes, that is test one.
Okay, so all those topics that I mentioned are not quizzes. That's test one.
Yes. Yes.
Okay.
That is test one, and it counts 20%. Yes, you're quite right. Yes.
All right. Thank you, Prof.
Let's see. Someone said mic isn't working. Whose mic isn't working? Anushka, you can speak to me. I see your hand is up. Just unmute yourself.
Hi, Prof. How are you?
Fine yourself?
Fine, thank you. My colleague just asked a question about the quizzes. From my understanding, the quizzes are, I checked with Grace about that. Those are just to assist us to get to know. And you can change the answers. You can do it as many times as possible.
Okay.
But that is not the test. The test is under a different folder, and that there we have to do within a specific time limit. But the other ones are just just for us to familiarize ourselves with it. That's my understanding of it. Am I correct, or
You
am I
are
in?
correct. Sorry. Sorry, yes. I've worked out the quizzes and the questions or whatever, but Grace do all the administrative work. So sometimes I'm a little bit out of line with how she's doing it. But I assume you are perfectly correct, Anushka, because test 1 is formal. Test
Yes.
1 is a decision that you take, and once you open test 1, there's a time limit. And
Yes.
you only have a certain time to answer the questions. And that counts for a test. If you can open quizzes randomly, then I agree with you. Then that is just to familiarize yourself and to get to know more or less how the things are asked. But the work that you need to know is only the theory on your website. So you do not study any of the cases or the activities, only the theory on the website. Thank you, Anushka. Thank you
Thank
very
you.
much.
Thank you, Prof.
As I said, I'm a bit outdated with these things. Anyone else? Yes, there's another hand. Bruce, you can speak.
Good afternoon, Prof. How are you doing?
Find yourself.
Great, great. I just wanted to confirm, in fact, the answer to the question as to whether or not that test is due is only due on the 12th of May.
Okay, excellent.
For the benefit of that student.
Excellent. I had the 12th of May in my head, but I wasn't sure, so I didn't say. Thank you so much, Bruce. Yes.
That's
So it will
correct.
end on the 12th of May. So it is today the 3rd. So you still have 9 days to do it.
That's correct. I just want a follow-up question, Prof, pertaining to when you say that we basically just have to go through the theory, and the theory is what one needs to know in order to answer the multiple choice questions of test 1. Is that correct?
Yes,
Now,
that's
when you
correct.
say, Prof, when you say theory, I take it is those sort of preces that we could download pertaining to the different categories, constitution and the law, etc., etc., etc.
Yes, yes. In other words, only that is on the website. You do not have to worry about the activities. The activities are not tested. And that is one of the reasons why you will see the activities are sometimes emphasizing other aspects that is not part of the theory, so that we give you a wider scope of knowledge. But you are perfectly correct. Only those pieces in your study material that explains a concept, or the Constitution and medical law, or informed consent, only those parts are relevant for test 1. Yes.
Yes, thank you very much, Prof. I'm clear. I trust that
Okay, thank you so much.
also clear on that. Thank you very much, Prof.
Thank you. Okay, and people, anyone, feel free. Did you benefit by doing the activities? Did you learn something more? Was it interesting? Did you enjoy it? Or was it just too easy, like a comprehension test? Anyone? People, don't be scared. I'm just a normal person. Just tell me, because going forward, we don't know. I mean, your marks are good, which is a good indication that you understood. You understood the cases, you read it, you understood the questions. But yeah, I would just like to know whether, is it worthwhile? Are you benefiting from it? Tony, let's hear from you.
Thank you, Prof. Good evening, and good evening, my colleagues.
Yes, good evening.
Without further ado, I want to say this course has been so challenging. How do I put it? My brain is like things about civil litigation and things I know before. We are all connected. In other words, it took me back again to certain foundations. I mean, look at activity 6. I'm busy with it. Prescription, things that you just forgot, and then it's
Yes.
bringing me back to memories. Instituting what is it? Legal institution on organs of state. All those things.
Yes.
So, well, for me, I'm enjoying it. It's been so challenging because of time frame. But
Yes.
at least my head is all over the show. When I sleep, I think medical law. When I wake up, I think medical law. And it just
Yeah.
brought me back to litigation. And yeah, for me, thank you very much for. And then the questions, yes, they are not. It's not as if it's easy. It's just that it makes you to go back to study. You go back to research. You go back to case laws. Good one
Yes.
for me.
Okay.
Thank you.
Okay. Thanks. Thank you very much. Yes. I just want to make a last comment. If I remember correctly, it's your last activity. It's the case of the brain versus the HPCSA. I apologize for those of you that cannot speak Afrikaans. There's huge parts reported in the case in Afrikaans, but don't worry. You will be able to answer all the questions. The Afrikaans parts are basically the testimony of the young girl, but then it is sort of rephrased in English. So you're not missing out on anything. So I just wanted you to read that case I feel that's the best example to see all the processes of the HPCSA. Okay, then I'm going to start with today's lecture. Let's just see. Can you all see let me just minimize that one. Can you all see the slides? Then I will also afterwards have time again if you want to make more comments or make more ask questions or whatever. But as where I stand now, looking at your marks, I am very impressed and congratulations to all of you. Now just go over the last hurdle. Okay, so just a short summary of what we basically did last time is how to approach a medical negligence case. And I said to you, you consult with your client and you gather all the facts. Remember, I stressed that patients sometimes remember selectively and they might not give you all the facts. So make sure, ask questions, try to get as much facts as possible. In your mind, you test the requirements of a delict. You determine whether there's a cause of action. You think whether you will be able to prove causation. And then you ask your client what he or she wants. Remember, I said it may differ. Some people want closure. Some people want financial compensation. Some people just want revenge. And all of that will have an influence on how your client will approach the case. Remember, at the end of the day, it is you going to court, not the client. But if the client just wants revenge, they may just focus on all negative things and not on what actually happened. So just keep that in mind. Then you obtain the hospital and the doctor's records. And I've said that they're not supposed to give you the original. They will give you copies and you will have to pay for it. And remember, I said that book of Van der Heever and Lawrenson, very on expert witnessing, very helpful to indicate to you how to get the records. Just a short warning here. I've been involved in a case and we asked records from the pharmacy in the hospital and they provided it with us, for us. But for some or other reason, it didn't make sense. And then we realized that the person who made the copies only photocopied the front of the page and never the back of the page. So we got half of the information. So just check when you get your records from the hospital, if it's copies, that it makes sense, that there are not parts missing. And remember the unwritten rule in medical law, if it's not written down, it did not happen. And once you get very experienced, you will easily see whether a nurse or a doctor added something afterwards. You can see the difference in handwriting. You can see it. Your eyes will just tell you that maybe this was not written on the same day in the record. So check out for things like that. And everything is important. When we teach nurses and doctors, we also stress that they must keep record, because it doesn't help that the nurse go to court and say that she did give the medicine. She just forgot to write it down. Then the law treats it as if it never happened. So if it's not written down, it did not happen. Then you compare your client's version with the records that you got and see whether there is a story unfolding, whether there is a cause of action, whether there will be a way to prove causation, and then you take it from there. And remember always what I said, do not jump the gun and immediately decide, yes, this is absolutely negligence. You must do the test of negligence. Even if it's a misdiagnosis or an error of judgment, remember you have to do the test. How would a reasonable person from the same field of expertise have acted under the same circumstances? Let's talk quickly about that Van der Walt case, the criminal case. One can ask, is it practice that gynecologist who helped a person to give birth and she got ruptured and there were tears, that he will try to stop the bleeding and then leave? Or would the reasonable gynecologist take the patient to an operation theater where there's perfect lighting, where he can stitch up what have happened? Remember always the test. So everything that goes wrong is not necessarily negligence. And then sometimes you have to tell your client and say, you are so sorry and you sympathize, but there is just no case because it's not worth it. It's expensive to go to court. So sometimes you will have to tell a client there's no case. You will not be able to prove it. Or remember what I said at the beginning, if you cannot prove damages, then it is not worth taking the person to court, because damages is one of the requirements of a delict, and if you cannot show to the court what damages you have suffered, there is no case. Of course, that's not the end of the road. You can report the doctor or the health practitioner to the HPCSA, where they can go through a disciplinary process and the person may be disciplined. But remember, then the only reward then for the patient is the satisfaction that something happened with the doctor. Okay, and in order to build your case or to be able to prove your case in court, you will need an expert witness, an expert in the same field as where the doctor is that is presumably that was negligent. And I referred you to the SAMLA website, the South African Medico Legal Association. They've got a list of experts willing to testify in courts. Otherwise, you can go to universities. Otherwise, you can ask your colleagues and they might refer you to an expert. And then you start preparing your documents and you decide on what basis will you sue the doctor or the hospital. Is it on the basis of a delict? Is it on the basis of a contract or on both? And remember, when you sue a public hospital, you must always remember the institution of legal proceedings against certain organs of State Act, that you within those time limits. Otherwise, they can raise an exception. Okay, then the case IM and another versus MEC for Health in the Mpumalanga court, that was a case of cerebral palsy. and it was case selection, and it also addressed prescription. So I wanted you to do that case, as one of you have said, it reminded you about prescription. I'm going to elaborate a little bit on prescription tonight, but I also wanted you to see that an attorney should not be guilty of case selection, because in that case, the judge said, beware of case selection, for justice is not a business and not about profit or loss. So the reason why that case was asked in an activity is specifically to indicate to you that even attorneys are not always angels. The same with doctors. You get excellent doctors, you get bad doctors, you get excellent attorneys and advocates, and you get attorneys and advocates that will take chances. So that was the reason for that one. Then I'm just drawing your attention again to the Government Gazette of 7 February 2020. And it specifically addresses Rule 41A, and it indicates that mediation should be used as a resolution mechanism in medical negligence cases. In the first webinar, I've also said that you should go to the South African Law Reform Commission's website and see that they have a project paper out for public comment, where they also say that there must either be a cap on the damages that you can claim, or there should be compulsory mediation for medical negligence cases. And that rule became operational on the 9th of March 2020. In order to do mediation, you need to be an accredited mediator. In other words, the knowledge that you have gained in this course that you have done, that will assist you. That will assist you tremendously. But you will not be able to mediate unless you are an accredited mediator. And you will have to go through training. You will get information on where to get the training. I hope, I haven't checked, but it used to be on the SAMLA, South African Medical Legal Association's website. But I also know you can Google conflict dynamics. They fall under the auspices of the University of Stellenbosch, and they are accredited trainers of mediators. And you can also Google UCT, the University of Cape Town, as I know they also train mediators. Now, I can just share from my own experience that the training is extremely intense. We did it for 7 days in Sandton. I had to go to Sandton for 7 days, every day at 6 o'clock with the Gautrain, got home at 7 o'clock, then had to prepare. We had a lot of trial runs where you were videotaped, and they indicated to you what you are doing right, what you are doing wrong. So if you find it difficult, don't think you're alone. I found it extremely difficult. I think the reason is because we are lawyers, or we are trained in the law, we think in a certain way. And we think differently from, say, for example, a psychologist or a psychiatrist. So what I did, which they showed to me on the video when I did a mediation, a mock mediation, I took control of the whole situation, like in a disciplinary hearing. And you're not supposed to do that. A mediator must be objective, and the mediator is not there to dictate how the people should react. The mediator is there to ask the parties, what do they want? In other words, when you are a mediator, you will ask the patient, what do they expect from this mediation? What do they want? You will ask the doctor or the hospital representative, what do they expect or what do they want? But you're not supposed to get involved. But yes, if you want to take this knowledge that you have gained in this course further, that is a good thing to go and do the accreditation, become a mediator, and then this medical law knowledge that you have will help you to mediate, although you stay independent, objective as a facilitator and not running the show, but you will have the knowledge in your head. But yes, I enjoyed it, but it was difficult. It was really difficult. So keep that in mind. So today we are looking at the grounds of justification. Remember, you're not always going to defend the plaintiff or the appellant. Sometimes you can also be the defendant. You can work for the state attorney or you can work for a hospital. And then when you get the summons and you see that they are assuming medical negligence, you must now see what can your arguments against that be? And the first one is that the patient gave informed consent, and I will elaborate on that, or the doctor or hospital acted in an emergency situation. Sorry, I'm just drinking water. Or there was statutory authority to do something, or you acted out of a court order. Now, if those are just examples, there can be more, there can be other. But their presence, and just look at the wording that we use. We speak of wrongfulness in a delict, but unlawfulness in criminal law. Okay, then other grounds of justification could be contributory negligence, prescription, or that causation could not have been proved. So now I'm going back and we go through them one by one, but we have spoken already about informed consent. Informed consent is the two most important words in the medical field. Informed consent. Why? Because it also goes back to the Constitution, Section 12, your right to self-determination. In other words, only you yourself can consent that something should happen with your body. The best case, or the locus classicus, so if ever you have to do a case on informed consent, then you refer back to Castell versus De Greef. And I'm just throwing this, think about it. I'm not saying I'm right. I'm not saying I'm wrong. I just want you to think. In that Van der Walt case, the criminal case, where the lady insisted on giving birth naturally, and then eventually the baby was too big and she bled to death. Do you think, remember, you've read the case and you've seen that he never testified himself, nor did he call any witnesses or an expert witness. He did not testify at all. He came with no argument against what the state did. So just think, play in your head with the thought, whether you think he could have argued, but the woman gave informed consent to give birth naturally, knowing that it is a risk because she is too small. And he explained to her that a cesarean section would be better, but she insisted on natural birth. And the consequences, the ruptures, and eventually the loss of blood, and she died. Just think, I'm not saying it would have worked, but I want you to think about things like this. Whether if you were his legal team, do you think it could have stood the test if you argued that the woman gave informed consent? So the Latin in which all of this comes together is volenti non fit injuria, and that just means that to him who consents no harm is done. In other words, if you go on a soccer field or a rugby field, you cannot sue the other players because they hurt you. because you did it with consent and you knew that there was going to be some harm. So please go back to your study material and see the requirements for valid consent. And in a nutshell, I'm just going to explain this. Valid consent is you, the patient, should understand what the doctor is saying. In other words, the doctor must speak in a language understandable to the patient, but also on the level of the patient. In other words, is the patient an intellectual person or an illiterate person? So the duty is on the doctor to get informed consent. Just a general remark here as well. In hospitals, it is practice that when you are admitted, that the nurse takes you to the ward and she has that file and she goes through all these documents and asks you all the questions. I know that is how it is done in practice, but it is actually not correct, because at the end of the day, in the doctor-patient relationship, it is the doctor that must get the informed consent. One can assume that before the hospitalization that the doctor discussed the procedure with the patient in his or her consulting room. So that will be the correct way to do it. But the end duty is on the doctor and not the nurse, although the nurse will do the practicalities. Okay, then remember also that apart from informed consent, as I've indicated, linked to the Constitution, the right to self-determination, the National Health Act also determines that the user, they use the word user and not patient in Section 6, that you must get informed consent. The same with the Mental Health Care Act. It is also in the Children's Act. It is also in the Choice on Termination of Pregnancy Act, and it is also in the Consumer Protection Act. So informed consent is extremely important. And as I've said, if you did not give consent, then the doctor can be guilty of assault. So informed consent, the best way to get informed consent is in writing. But if you read the case of the Beekes case, you will see there it was the patient's word against the doctor's word. So the advice to doctors is to get it in writing. Even if it is not a form or a whole written document, the doctor can just make a note in his file saying, I spoke to this patient on this date. I explained to her that we're going to have a mastectomy and remove her breast. She asked some questions. I explained and she is satisfied, and he signed. That is fine. That is absolutely fine. Usually when you admitted to a hospital or where you go for a big operation, they will, the anesthetist always, they will have informed consent. You will physically sign a form and you will do that. But just remember that certain acts also prescribe it. And you can go back to Castell versus de Greef if you have a possible case. Okay, see, let's see a kind of an example. The Kuneni family has 2 children. John is 8 years old and healthy. Frans is 6 and he suffers from Down syndrome as well as other illnesses. So he needs a lot of attention. And he is financially draining the family. Frans's parents met an attorney who is an expert in medical law at a braai. And that attorney asked them whether tests were done before Frans was born to determine if everything is fine. So the woman answered and she said, yes, the tests were done because she is not young anymore. So she was scared that the baby could possibly be Down syndrome or had some or other abnormality. So she went for test. And then the doctor did the tests, looked at it and told her that the baby is perfectly fine. And the woman specifically went for those tests because if the doctor was not negligent and told her that the baby has the symptoms of Down syndrome, she would have aborted the baby because that is a legal abortion in our country. Now, the doctor gave her the wrong advice. The baby was not aborted. The baby was born. The baby now suffers from Down syndrome and is costing a lot of money for special care, etc. So what will your advice be to the woman? Remember, the baby, or France, the baby that's suffering from Down syndrome is 6 years old. Okay, so the first thing that you must realize is that because France is already 6, can you see that the parents cannot institute an action? The parents on their behalf, because 3 years have already lapsed. So they cannot claim damages or they cannot claim the cost to look after France. So the only person in this example that can claim is France himself. Now, this is very important because for many, many years, this was not an option in South African legal system. It was seen as contra bonus mores, because it means the child institutes action and the child then argues, of course, with the help of his parents and legal people. The child argues that he or she should never have been born. And we call that claims for unwanted life. Now, that was unwanted life or wrongful life. That was not allowed in our legal system until the case of, which is in red there on your screens. It's a constitutional court case of H versus Fetal Assessment Center. What happened in that case is more or less the scenario I gave to you, but the baby really suffers from bad illnesses apart from Down syndrome. So they instituted action in the High Court in Cape Town, and then the defendant came with an exception and said that there's no cause of action because wrongful life claims are contra bonus mores in our legal system. And then the court upheld it. But then the child, with the help of the parents, being represented by the parents and the lawyers, approached the Supreme Court of Appeal, and they had arguments there. And then this, not the Supreme Court of Appeal, sorry guys, the Constitutional Court. And the Constitutional Court said that there can be such a claim. The Constitutional Court did not entertain the specific facts of that case. They just said that the parents must go back to the High Court and institute action again. And then the defendant cannot raise the exception that it is contra bonus mores anymore. But it still have to be proved on the facts. So this is very important because a lot of negligence cases happens in gynecology, where gynecologists, obstetricians and gynecologists, where the women specifically ask that they should do certain tests. Then the tests are done but interpreted wrongly. Remember, once again, the test that one must apply, will the reasonable gynecologist of the same field of speciality have done the same mistake? Then it's reasonable, otherwise it is negligent. So we distinguish between, firstly, unwanted pregnancy. That is where the woman or the husband goes for a sterilization. So the man goes for a vasectomy, comes home. A few weeks later, they have intercourse again, and the woman falls pregnant. And then they realize that the vasectomy was not done correctly. Then the parents can claim on the basis of an unwanted pregnancy, and the damages they suffer will be the upbringing cost of that unwanted, between inverted commas, baby, but it's a healthy baby. So it's a healthy baby, but the baby was conceived, although one of the parties thought he or she was sterilized, but the sterilization has gone wrong. Then we've got wrongful birth claims. And wrongful birth claims you will see in Friedman versus Glicksman and Stewart versus Botha. And that is where the parents of a disabled child go to court and claim damages because they would have aborted the child. Now they have the child and they need money to care for that child. But it is the parents that's claiming damages. Do you see the difference between wrongful birth and wrongful life? Wrongful birth must be done within 3 years before prescription can be raised. It is done by the parents. They say they would have aborted had they had the correct information, and therefore they claim damages to raise this child with special needs. In wrongful life cases, it is the child that institutes the action with the help of his parents and legal team, but it is the child that is claiming damages for being a child with special needs. And then when it is successful, the damages awarded will go to the child. In other words, it will be kept in a trust for that child. Whereas in the case of wrongful birth, the money will go to the parents to use it as and when the need arises. So it's quite important to take note of these. Sorry, I'm just drinking water, of these three claims, because it happens in our legal system that gynecologists makes mistakes. Okay, then your other defense can be you acted in an emergency. Now, under emergency, we've got the Latin negotiarum gestio. That is where someone took control on your behalf. They do not need the consent because you were unconscious, either in a coma or shock, and it is life-threatening. So that will typically be the ambulance workers or the emergency workers. They will come at an accident and then they will take charge of the situation. They don't need your consent to resuscitate you. They will just take control, resuscitate you, take you to the ICU because your life may be dependent on that. Very interesting. I don't know whether I've shared with you is that my husband and I were bikers, so I never drove a motorbike myself, but I was the passenger. So I was thinking of having a tattoo on my arm saying, "Do not resuscitate," because I always felt if we were to be in an accident, I would rather be dead than a paraplegic. Well, that was my personal feeling. Because I'm older, I had a very nice life. My children are grown up. So I'll rather die than be resuscitated and then end up not being able to look after myself. So one day I spoke at a seminar for emergency workers, and I asked them, what is the legal position if they see either I've got a wristband or a tattoo or whatever indicating do not resuscitate? And very interesting, they then said they cannot. They have to resuscitate because it depends on the grade of emergency worker they are at, grade 1, grade 2, whatever. They're not allowed to make a diagnosis. So they cannot diagnose and decide that I'm going to be paralyzed and therefore leave me. They have to resuscitate, go to the ICU. The ICU doctors said they will also resuscitate because of the time pressure in an emergency unit. They will also not be able to make a very informed diagnosis whether I will be paralyzed or not. And they will also resuscitate. So the bottom line is everyone, the do not resuscitate is in a certain sense worthless unless it is, for example, a 85-year-old person that goes for a hip replacement, and then there's a problem with breathing, etc., etc., and then the doctor can say, but this woman had a do not resuscitate wish, and then they can let her safely go. But yeah, it is just one of those things to tickle your brains again. Think about it. Let's say I am in an accident. I do have a tattoo saying do not resuscitate. They ignore it. They go. I end up a paraplegic. Whether I will have a case to say, but you violated my right to self-determination. I don't know about a case like that, and I don't know whether it will be successful or not. So for now, I accept what I'm told, that the people say they cannot do that because they cannot make an informed diagnosis. Okay, but just remember that in an emergency situation, of course, your consent is not necessary. In the National Health Act, they also indicate to you who should consent on your behalf. For example, if there was an accident, they will take you to ICU, and then they will contact your next of kin in the specific order prescribed by the Act and ask for consent. Let's say they have to amputate a leg or something like that. Then the order is prescribed in the National Health Act. Okay, then blood transfusions. You can read the case of Hay versus B or Phillips versus de Klerk. If you are an adult of sound mind, then, and you are of the Jehovah's Witness faith, where you do not want a blood transfusion, then you can refuse it and it must be respected. Or if you gave your husband or your wife the power of to take decisions on your behalf, should you end up in a situation where you cannot decide, then they can take decisions on your behalf. Adults. If it is children, you will sometimes find in hospital that a child that's now below the age of 12 needs a blood transfusion urgently in order to save his or her life, and then the parents refuse and say, but they are from the Jehovah's Witness faith and they are against a blood transfusion. The Children's Act have now changed the position, and the doctor can overrule the parents if it's in the interest, the best interest of the child. So just remember that if it's in the best interest of the child, the doctor can overrule the parents according to the Children's Act, and he or she need not go and get a court order anymore. And then I refer you there to the Namibian case of ES versus AC, where the woman was from the Jehovah's Witness faith. She needed a blood transfusion. She just gave birth. She had 2 other minor children. And then her brother insisted that she should get a blood transfusion. Her husband said no. She eventually did not get a blood transfusion, but then approached the court for clarity. Namibia do not have a constitutional court, so she went to the Supreme Court. 3 judges, 2 judges with the majority judgment said that the woman, her choice, because she's adult and she was of sound mind, her autonomy trumps the argument of it is in the best interest of the children to have a mother, and that was the minority judgment. So that is just interesting concerning blood transfusions. Just also remember that nowadays they've got other products. So in olden days it was more of an issue, but now they can give you synthetic products and not a real blood transfusion anymore. So this issue is not that critical anymore. But just remember that children below the age of 12 can be the doctors can overrule the decisions of the parents because of the Children's Act that emphasizes the best interest of the child. Now, the question is, while you're busy with a procedure, are you allowed to deviate? For example, you go in for a biopsy. You go in for a biopsy for a lump in your breast. If the doctor then find the lump and see that it is cancerous or that it is malignant, can he then just remove the breast? This is a difficult one. It depends on whether he or she will improve your health or not. So, in other words, the best way to circumvent this is when you speak to it can be a woman or a man. Let's say the man has a liver problem. And the doctors say, we're going to theater for a biopsy to see what is wrong with your liver. But if you are opened up and I see that it is really, really terrible, do I have your consent to remove half or 3/4 from your liver? So, in other words, anticipate beforehand the worst case scenario and speak to the patient about that and get his or her consent so that you can carry on in the theater. Otherwise, if you deviate from a procedure, it can be argued that you did not have informed consent. That's also what happened in the Beekes case, also a little bit in the Isaac versus Pandy case, that there was a deviation, a communication problem, because informed consent is so important. So the best I can say there is if you deviate from the procedure for which you had informed consent, it must be in the interest of the patient or to improve the patient's health. So let's look at a case scenario. Now, check the age. Tandu is 14. He has a chronic kidney disease. He requires a blood transfusion, which could prepare him for a kidney transplant. The parents refuse as they are against blood transfusion because of their religion. It is clear that Tandu will not survive without a blood transfusion. Tandu speaks to the doctor and indicates that he does not follow the same religion as his parents and would like a blood transfusion. What now? Let's say you are the legal representative of the hospital and the doctor contacts you. What will your advice be? So we go back step by step. Remember, now we will focus on the Children's Act. And the Children's Act in section 129 say that a child of 12 and older who is of sound mind and understand his or her situation, in other words, they are mature, can consent to a medical intervention. And he can even consent to the kidney transplant if he's because he's 14, he just needs the assent, not the consent of his parents. So okay, so your advice as legal representative should then be go forth, give the blood transfusion because the child is above 12, and then you will just make a note that Tandu is 12, he knows what's going on, he seems mature, he wanted it, it is in his best interest, and therefore the parents can be overruled. Just as a side note, a hospital once called me and said that a child of 4 years was calling all the nurses baboons in the hospital. So the nurses got extremely angry and they made a note in the child's file that the child is misbehaving and the child is calling them baboons and they don't like it, etc. So the mother of the child came to the hospital and she looked through the file and she saw the note. And then she went to the hospital management and she got her lawyer and she insisted that that inscription should be removed from the child's file. So what will your legal advice be? The mother's argument was that the child will be in and out of hospital because of an illness a lot of times. And the file will travel with her. And if wherever she goes to other hospitals and they see that this child is rude and misbehaving, it will count against her in how the hospital will treat her. So the mother insisted it should be removed. So you are the legal advisor. What will you say? Should it be removed? Should it stay?
It should stay. You can't remove them.
Okay. Think about it. Yes. Afterwards, we will have interaction if you want to elaborate. No, it must be removed. Remember that a child between 0 and 7 is not capable of being in control of what they do. They are not in Afrikaans, it's toerekeningsvatbaar, and now I can't think about the English. But they can't be held guilty because they cannot, they do not know the difference between right and wrong. Remember, 0 to 7 and 7 to 14, depending on the circumstances. So if something like that happens because the child is 4, then it must be removed because the child does not know what's right or wrong and cannot act accordingly. Okay. Then you can also argue contributory negligence. We've spoken about that in previous webinars. Remember the Dube with the plaster on his arm that delayed going back to hospital, and then his arm had to be amputated, but he was illiterate and he did not understand for what signs he must look out. He thought it was normal, so he did not go back to the hospital in time, and they then argued, but he contributed to the fact that his arm was amputated, but the court said no. He did not contribute because it was not explained clear enough to him for what side effects he had to look out. Now we come to prescription. And there you have to look at the Prescription Act. And also remember that I said in the previous webinar, I think that you must also go to the South African Law Reform Commission because there's a discussion paper where they are now also asking for comments on prescription. But in that book of John Sainer, in short, it is summarized: a debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises, provided that the creditor shall be deemed to have such knowledge if he could have acquired it by exercising reasonable care. Now, in your activity, you've also come across the Prescription Act and how it was applied. So there are 4 cases if you want to have clarity on prescription. The first one is extremely sad. And fortunately, with the Constitutional Court case, it has been overruled with the 2 Constitutional Court cases of Links and Loney. But in the Trutter case, the patient went to an ophthalmologist and there was something wrong with his eye, and it was the one operation after the other, and eventually he lost the sight. He could not see with the eye anymore. His argument was that the reasonable eye specialist should have known that he cannot perform that many operations one after the other. But he had a difficulty. He could not find an expert to come and testify on his behalf that the reasonable eye specialist will not do that. He just couldn't find. And the time went on and on and on, and eventually the 3 years, they passed that. And then he heard someone over the radio speaking, contact that person, gave the facts, and the person said, yes, I am willing, based on the facts that you've given me, I am willing to act as an expert witness on your behalf because I believe that the eye specialist should not have done that many operations one after the other. But when they went to court, the defendant came and said prescription. Already 7 years has gone by. Therefore, it has prescribed. And unfortunately, the Supreme Court of Appeal upheld that. But that was in 2006. Now, if you read the Loney case and the Links case that went to the Constitutional Court, that is more recent, the one in 2016 and the other one in 2018, you will see that they have changed the position a little bit depending on the circumstances. So those 4 cases will help you when you are faced or when you want to prescription just to check whether you've got a solid case, or if you are faced with prescription to go back and see how it was dealt with in these cases. When there are minors involved, remember prescription only commences when he or she reaches the age of 18. He or she will then have 1 year from that date of his or her 18th birthday to institute action. Can you remember that scenario that I had, that the little boy was 6? In other words, prescription will only start when he turns 18, and then he still has a year from his 18th birthday to institute action. So yeah, just take note of prescription. If you are for the defendant, then you will like claiming prescription, but just make sure of your facts. And of course, the court can overrule it depending on the circumstances. Then there is also something like divisibility of damages. That is where something went wrong. The doctor did something, but the hospital staff also. Remember, I said from at the very beginning that doctors are always independent contractors. They are not employees of a hospital unless they are working in the public sector. If they are working in the public sector, they are employees, and then the MEC of Health will be 100% liable. But if you see that case, Wright versus Mediclinic Limited, so that is a private hospital. So the facts were argued, and then the court came to the conclusion that the hospital was 40% negligent and the doctor 60%. And then you have to go to the Apportionment of Damages Act to determine who will pay what. But remember that in the private sector, doctors are always independent contractors. So it depends on the facts of the case, whether you are only going to sue the doctor or whether you are going to sue the doctor and the hospital. And then the hospital must come and say, but they should not be added as a party for this and those reasons, or it can be divided between the hospital and the doctor. Okay, then the last sort of part in your study material concerns statutory matters. So I've basically dealt with this in the first seminar. Sorry, I'm just quickly go mute or mute. Okay, I'm sorry, I'm just muting. Well, I heard someone speak. Okay. Remember, South Africa is a private and a public sector. You must know that, and that the NHI will only, if it happens, the plans are there, that it should be instituted in 2026. But until then, there's a private and a public sector. And then the Constitution is always in the background. Remember, the National Health Act is important because that indicates informed consent and what can and cannot be done and where to complain, etc. It's all there in the National Health Act. The Health Professions Act, that act is necessary to understand for the registration of health practitioners. Everyone that falls under the HPCSA also falls under the Health Professions Act and must be registered there in order to practice. But remember that nurses has their own council. They do not fall under the HPCSA. They fall under the Nursing Council and they've got their own act, and the same with the pharmacists. Then just take note that pregnant women and lactating women and children below the age of 6, they are entitled to free healthcare. By the way, I think in your theory it states 7, but it's 6 years of age. In cases of an emergency, we spoke about this at the first webinar. If it's a life or death situation, the private hospital should stabilize the patient at no charge and then move him or her to a public hospital. Although this doesn't always happen, that is how it is supposed to happen. Then I also want you to remember that you must continuously, when you do your research and you prepare your case, never forget about the HPCSA. If it is a health practitioner registered under the Health Practitioners Act and registered at the HPCSA. In other words, this will not be relevant if you want to charge a nurse. But this will definitely be applicable if you are building a case against a doctor. The booklet numbers may differ because it is updated on 2 years or 3 year basis, and then they add information, etc. But there you will see the guidelines, the ethical guidelines for health professionals, the rules that they have to adhere to. You will find the Patients' Rights Charter there, and you will find all of this on the website of the HPCSA. You will see the costs that doctors may charge, and people have the right to complain if they think that the amounts charged are perverse or too much. They can complain, and then the HPCSA must investigate and come back with an answer. Then, if you want to do research, what are the ethical guidelines? If that's all there, then of course, confidentiality, how to keep patient records, how to canvass for patients abroad. That happens a lot with plastic surgery. But okay, you will get all the information there and you will see there what is expected of a reasonable doctor. And then you can measure your case scenario that your patient told you about against that to see whether there is a possible case or not. And then I've just added there, you may also consult the website of the South African Medical Association, SAMA, because they also have a lot of information to guide doctors on how to act, etc. Okay, now, if you do not want to start a civil action, in other words, you do not want to go litigation, maybe you have tried mediation or you don't even want to go there, then you can start. Some people use the HPCSA to see. And then if the HPCSA finds the health practitioner guilty, then they go to court. So it is sort of a test to see first whether there is a case or not. So there's nothing that say you're not allowed to do that. So if you hear something went wrong, it can either be through an attorney or the patient can do it on his or her own. And you will get all the documents and the guidelines on the website of the HPCSA. So you report. You will write a report of what happened, what did the doctor do, and that you feel he or she acted unprofessionally. That will not cost you a cent. So you will send the report to the HPCSA, and they then have to, it is compulsory to investigate. So the legal department will read through the claim. And if it's minor, it will go to the ombudsman, and the ombudsman will sort of mediate between the doctor and the patient and try to settle the matter. If it is more serious, not minor enough for the ombudsman to solve it, then there will be a disciplinary inquiry of unprofessional conduct. In other words, a lot of research will be done by the HPCSA. They will get the hospital records. They will interview the doctor who is alleged to have done or acted negligently. So there will be that whole inquiry, as you've seen also, or you are going to see in the De Bruin case. Then there's a disciplinary hearing, and at that hearing, they will now, the doctor will be able to call witnesses, cross-examination, etc. And then the disciplinary committee will reach a decision, and they will then inform the doctor of the decision. If the doctor or the health practitioner is not satisfied with the decision taken, he or she can appeal either to an ad hoc appeal committee, or he or she can appeal to the High Court. And that process you will also see in the De Bruin case, that he appealed to the High Court. He actually appealed and asked for a review, but it was then handled as an appeal to the High Court. And then when not satisfied with the judgment of the High Court, you can even then go to the Supreme Court of Appeal. Unfortunately, there are not many cases, or I do not have access to all these cases. Unless it ends up in a High Court or a Supreme Court of Appeal, it is not in the public domain, although you can at the on the website of the HPCSA see which doctors have been charged, and you can see the punishment they got. So it's always good when you want to go, for example, for something special like a breast lift, or you will go for something on your face or something like that, then just to quickly go and screen your plastic surgeon to see whether he wasn't found guilty of some or other misconduct. It's there on their website, but you don't get the cases, and that's why we've chosen the De Bruin case, because it indicates to you all the processes that he went through, and it ended up in the Supreme Court of Appeal. So that is a very good example for you to see how it works. Then I'm just making a comment. If you are working with the Road Accident Fund and you want to see what happens if the serious injury claims are rejected, myself and the neurosurgeon wrote an article in 2016. And if you want the article, just send me an email and I can send you a copy. Also, just take note and ask yourself whether things haven't changed, because I'm not an absolute specialist in practice on the Road Accident Fund. I might have missed something, but we discussed the appeal process in that article. Okay, then be careful when you have a case and it concerns a mentally ill person, the same as what I continuously say with children. You have to go to another act. Sorry, the Mental Health Care Act, because you're only allowed to have the patient for 24 hours. The review board must be involved, etc. So there's minor detail. And it is not the focus of this course to deal with exceptions. So I just want to draw your attention. The same with children, that you must go to the Children's Act. Mentally ill people, you have to go to the Mental Health Care Act and prepare your case then based on what these acts say, as they have specific determinations for the mentally ill. Then lastly, I just want to mention the Consumer Protection Act. I haven't come across any medical negligence case yet that was fought on the basis of the Consumer Protection Act. But it is not impossible, because medical negligence or medical services per se are not excluded from the Act, therefore they are included. So when you think about the Consumer Protection Act, you must always remember the Afrox case. Remember, I said to you, the Afrox case, unfortunately, is only reported in Afrikaans. But the bottom line of that case, if you Google it, you will get English summaries of it. In that case, it was said that the indemnity clauses in a hospital contract, the admittance contract of a hospital, is valid. It is valid. Now, we as medical law specialists, we argue that since the Consumer Protection Act came into play, that case can actually not stand anymore. But it still stands today, because it's a Supreme Court of Appeal case and it has not been overruled yet. So until such time that another patient takes a hospital to court for the indemnity clauses in their contracts, then those clauses will stay valid until the court then declares it under the Consumer Protection Act as not valid. I hope that most private hospitals have changed their admittance forms to comply with the Consumer Protection Act, but I'm not sure that that is the case. Remember that a patient under the Act becomes a consumer, and the service that is provided is the treatment of the patient, and of course then the health practitioner is the service provider. Now, under the Consumer Protection Act, there are 8 fundamental consumer rights, and you will agree with me, they resemble the Constitution. Everyone is equal before the law. Then you've got a right to privacy. Once again, it's doctor-patient confidentiality, informed consent. Autonomy, you can choose who treats you. You must be informed of the risks. And the interesting thing about the Consumer Protection Act is, let's say, for example, you have heart problems and you must get a pacemaker. So you go to the cardiologist and he puts in a pacemaker and you're fine. But a week later, there's huge problems and you nearly die. Then you can sue the whole chain. You can sue the people who made the pacemaker, the engineers who made it. You can sue the distributor. You can sue the importer in South Africa. You can sue the person who provided it to the cardiologist, and you can sue the cardiologist. So that is what the Consumer Protection Act did. It made this, you can now sue the whole chain, the producer, the importer, the distributor, the retailer, the doctor. So that whole, you can sue all of them. Of course, it will be easiest for you to sue the doctor because you will not know all the other. But if you do a little bit of research, you can sue all of them. So that is what the CPA basically did. And if you have a problem, you can go to the National Consumer Tribunal, or you can ask the National Consumer Commission to do an investigation. Then there's another act that you must remember, and that is POPIA, or the Protection of Personal Information Act. Remember that health records are special information, and there's still a little bit of debate whether it can be de-identified or not. But the Act provides that doctors and hospitals, etc., may share records because that is just practical. But be careful, or if you come across a set of facts and you see that the POPI Act has been violated, go intensively through the detail, bearing in mind that health information is special information. So the rest you can go through yourself. Okay. So that is all that I wanted to say. The case that I refer to there is a very interesting case, and I want to end with that saying, those of you that enrolled for this course and you thought that justice will always be done and there's always answers and doctors are just messing up and it's easy to prove negligence, this case is quite an eye-opener. Because sometimes the law does not have an answer. So everything is fine, but the law doesn't have an answer. And what do you do? In this specific case, it was a Singaporean lady. She was married to a Caucasian German man. They could not conceive naturally, so they used in vitro fertilization. They gave birth to a little boy. So it was her egg, the mother's egg, and the father's sperm. But the egg and the sperm came together in a tube. And that is what we call in vitro. And then it was planted back into the woman's body. And she gave birth to a boy. So 5 years later, they went back to that same laboratory because that laboratory still had some of his sperm, frozen sperm, and had some of her eggs. So they told the laboratory, take my egg, take my husband's sperm, put it in a tube, put it back into my body, so we want another child. And the laboratory did as they were told. And then when the baby was born, the baby was a dark Indian baby. Now, what now? They wanted a child, but they did not want that child. What must the law do? Of course, obvious, there was negligence at the laboratory, so the wrong sperm was used. Instead of using her German Caucasian husband's sperm, the laboratory took the sperm of an Indian donor. And that is why when the baby was born, he looks like an Indian. But what must the court do now? There's a baby, a perfectly healthy baby. The parents wanted a baby, but now it's a wrong baby. And I want you to see that the law and the courts do not always have the answer. And medical law is so exceptional that technology has progressed to such an extent that the law is behind. And what should the law do? What should the law do in such a circumstance? Of course, the laboratory that messed up the sperm got fined. That's easy. There was a contract, the contract was broken, and they were fined. But in delict, what damages did they suffer? Basically nothing, because they wanted the child. But now you cannot leave it unpunished because they did not want that child. So the damages were awarded in a smaller amount just for the lack of genetic affinity, the fact that the daughter, the baby girl, and the German father were not genetically linked. But if we think further, fortunately, the mother and the father accepted the child and they're happy. But what if they got divorced? Remember, then the father is not the natural father of the girl. So there can be other things. But I want you to remember that medical law is very interesting, but medical law doesn't always have the answers. And with that, I'm going to end. And also, whether you agree, it was a question asked in your assignment that should doctors be punished criminally? Do you agree with the Van der Walt case or not? These are debates that's currently going on in medical laws. Should doctors be measured against a different yardstick than an ordinary person or not? What is your feeling? Are there too many medical negligence cases? Or my personal feeling is that it is so expensive and so time consuming to prove medical negligence, that I am all in favor of mediation. But you've got knowledge now, and now you have to decide for yourself. So that is all that I wanted to say. Now the floor is open. You can ask questions, you can make comments, or if you feel you've had enough of me, you may leave without apologizing. It's fine. I won't feel offended. So anyone? Yeah, I see there's a comment by Diana that she loved the course, horrified with the cases, especially the babies dying. I agree with you, and it's going to sound terrible, but I feel more for the babies that ends up with cerebral palsy. In other words, they don't die, but because of a lack of oxygen, they suffer from cerebral palsy for the rest of their life. And I find there's no consistency on how courts approach cerebral palsy cases. And I also get the feeling sometimes it depends on your legal team, whether you are going to be successful or not. Okay, let's see. Bruce, your hand is up, but is it a historical hand or is it a new hand?
Hi, Prof. No, it's a new hand. It was up earlier just about
Okay.
the one was about the children between 0 and 7, because in criminal law, those
Yes.
children would then be considered criminally incapacitated, and then
Excellent.
between 7 and 14, it's limited criminal capacity.
Yes.
To answer that one.
Excellent. That was the words I was looking for. Yes.
Thank
Yes,
you.
excellent. So between 0 and 7, yes. So that inscription cannot stand on the file because the child was only 4 years old. Thank you for those words. I just couldn't remember it in English.
That's correct. I just wanted to comment about your comment
Yes.
about I think this Rule 41A pertaining to the mediation as a dispute
Yes.
resolution mechanism. My question is, at this point in time, is it still what you call it, where the person has a choice, the two parties, or not?
It is actually compulsory, but there's not enough mediators. There's not enough mediators, so the court cannot enforce it. So usually in the pre-trial conference, the parties will talk about it and whether they are willing or not, and then it will be reported to court. I think the idea of the court is eventually to get it at a stage where it is compulsory. But at this stage, although it seems compulsory, it is not enforced because there's a little bit of lack of mediators and processes in place. So it's slowly getting off the ground.
Okay, my comment on that, Prof, is that's a bit unfortunate. Because obviously with regards to the time factors involved, it would have considerably obviously cut the time when instituting such cases, as opposed to going through these lengthy processes which could take 10 years or more, depending on the circumstances. My personal feeling is that I trust it can become compulsory to the extent that where parties now agree that, and it should be a cost factor to be considered. If a party, my personal view is, if a party refused for the mediation part, and then at a later stage, now it took 10 years, and with regards to the additional cost, that should be a question maybe the courts could then start considering in terms of the cost awarding of cost to the party who now refused a matter that was so obvious up initio that it should have actually been mediated and settled.
I absolutely agree with you. That's why the Law Reform Commission have now published that document for people to comment, because the attorneys, especially the big attorneys for firms, of course, they are not 100% in favor of mediation because they go on contingency, they have contingency agreements, and if the contingency agreement is 25% and the award is 20 million, then that is a quarter, then they have, 5 million. So the big attorneys firms have a little bit of reservations, but the Law Reform Commission is now doing research, and I assume it will go the mediation way. But yeah, at this stage, it is there as a rule, but it's not enforced.
Thank you, Prof.
Okay, let's see. Yeah. Tony, I see your hand is up, or is it an old hand?
No, Prof is a new hand.
Yes.
Once again, thank you very much for these lessons. You've inspired us all very, very, very well. Thank you once again. My question is, or my concern is, when you were teaching us today, you were using the word in the best interest of the child. Is there a difference between the best interest of a child and the interest of the child? Just asking.
I don't know if you ask a linguist, but since the Constitution came out and in Section 28, it speaks of the best interests of the child. And then after that, the Children's Act came and they speak. It is the same as a fit and proper person for the legal profession. It is nowhere defined. Who or what is a fit and proper person? Where can you look up a definition? It is a subjective decision of the person interviewing you or what. And that is the same with what is in the best interest of a child. It is not fixed. It is not one definition. It depends on the circumstances. So let's say in a medical sense, when it's a life and death situation, of course, the best interest will be that the child should live. You should do everything you can. Okay, I want to give you a scenario quickly. Let's say it's a girl of 13. She had heart operations, about 5 or 6. She must now go for another one. And she refuses. She said, I've had it. No more operations. If I don't get this operation and I die, so be it. I just cannot take it anymore. From I was small, I've been in and out and I can't take it. What should happen? She's 13. What do you think should happen?
Are you asking me, ma?
Yeah, I'm asking you.
Applying what I was just asking, then the best interest of that child should come to play.
You see, and I specifically said she's 13 because now the Children's Act say a child of 12 can consent. So a child of 12, if a child of 12 who's mature enough can consent, then one assumes that a child of above 12 can also refuse. So you can say she's 13. So according to the Act, if you interpret it that way, she can basically refuse to have the operation. But now the snag comes. What is in her best interest? Okay, and on that basis, this is actually a case that happened in Britain. They got a court order that she should have the operation. She eventually went for the operation and lived happily ever after. But the question is, what if she refuses? Will they bind her to the bed and force her into the operating room? You see, that's why I say sometimes the answer is clear. Sometimes, let's say it was a woman of 23 and she refuses. I don't want a heart operation anymore. I had 15. I've had it. then you must respect it. Because every person has the right to refuse medical intervention. But now she's 13, so she's actually a child because 18 is the age of majority. But the Children's Act say above 12. But now the best interest sort of overrules that above 12. But can you see, it's sometimes not that straightforward. But yes, the best interest in a nutshell is not defined. It will depend on circumstances every time that you will take into account.
So it's just semantics to say best interest and interest of the child. Is that what you're saying, Prof?
Yeah, you can say the best interest, plural, or the best interest, singular. And it will say the same thing, and it will depend on the circumstances.
Thank you, Prof. Thank you so much.
Okay. Non-Dumiso and Thuli, I see your hand is up.
Right. Good evening, Prof.
Good evening.
Yes, my name is Non-Dumiso Ntuli from Botswana.
Yes.
And I wanted to find out, well, you stated earlier that there's a scenario that you stated that there was a 4-year-old child who was calling the nurses baboons, and that it was recorded in the medical records that he had been calling the nurses baboons. And you mentioned that that had to be deleted, that had to be taken out. So my question now is, how then do you reconcile that deletion with Section 17 of the National Health Act that basically provides that anyone who falsifies information or a medical record by adding to that document or deleting commits a crime, which is punishable.
Okay.
Yeah.
Okay. Interesting question. Very interesting. It is not a falsify or deleting. It should never have been recorded. If you understand what I say, it is not that you now delete something to hide something. The nurse that recorded it did not know that a child between 0 and 7, and remember in South Africa, Botswana might be different,
Yeah.
but in South Africa, a child between 0 and 7 cannot understand right and wrong. So the nurse should never have recorded it. So the fact that it is taken out is not hiding something or falsifying or deleting. It's just taking out that never should have been there.
Okay.
Yeah,
Right.
but
I picked
it's
up
an
in-
interesting, you thinking very interestingly.
Right.
Okay, let's see who else is there. Anyone else? I don't know. Anushka, is it an old hand, a new hand?
Hi, Prof. I think that's an old hand. I'm sorry about that. But
Okay,
I
no
just want to
problem.
say to you that
Yes.
it's been really interesting. And there's so many different acts that come into place. There's so many different things that you have to think about while you're doing it. And the causation aspect is something that really gets me thinking, because s- y- sometimes you might have a child that goes through all this trauma, but actually at birth, but actually turns out to be okay. What then would happen, because the mother at that point had suffered all of the trauma, the shock, and the the noticing that your child is sick, noticing that everything's delayed, but the child's come out okay. Does that mother still have a claim, or does it fall away because the child was normal?
Unfortunately, it falls away because
Yeah.
the child is normal. Of course, what the mother can do is once again report it.
Yeah.
Report it to the HPCSA, look in the National Health Act and report it to the process stated there. Speak to the media, whatever, get some, but she won't be able to litigate because
Yeah.
she will not be able to prove any damages.
All right. Thank you, Prof.
Okay. Sipho?
Hello, testing, 1, 2, 3, testing.
Yes, I hear you, Sipho.
Yes, hi, Prof. Thank you once again for the lovely seminars. Good evening to everyone else. Prof,
Thank you.
my is call it a quasi-theoretical question. So,
Yes.
do you know if you look at the road accident fund and all the changes happening there, and it's reached a point where there are way too many claimants and there's not enough money to pay out those claimants. When do you think, because I remember in the one webinar, because I mean, this would be an interesting field of law to be a practitioner in, but then, you know, one can also see you adding more injury in that, you know, if you go after, especially like the state hospitals, it will end up getting to a point where there's just not enough money. And I remember you did touch upon the fact of, you know, the money that needs to be going towards resources and salaries and whatnot ends up being affected. That's what's used for payout. So when do you think that it will reach a point where it just all boils over and kind of like comes crashing down?
This is now just my personal opinion. This is just my personal opinion, and you must see it like that. The road accident fund is wasting money because of incompetence. They cannot really run completely out of money. And why do I feel that way is because remember, every time that you put in petrol, you pay a levy. So they have a continuous income. And if you think how many people drive cars and put in petrol, so maybe there's a shortfall now and then, or there's a backlog because of maladministration. But actually, they can never 100% become insolvent because every month, every person that puts in petrol contributes to them. Do you hear what I'm saying? So it cannot really dry up unless it's done by mismanagement. It is a little bit different with public hospitals because public hospitals, they have a budget. So first of all, money from Parliament is given to National Health. National Health then distributes it to the 9 provinces, and then it must be managed there. If there are then too many claims of over 20 million, then of course the funds will be depleted and that province will not be able to buy the necessary resources. But the road accident fund, the public hospitals gets money per financial year, but the road accident fund gets money every month. Every person that drives a car that puts in petrol pay a levy. So there's a continual pouring in of money. It is not just for 1 year according to a budget. If you hear what I'm saying, as I say, this is my opinion. So don't state it as a fact, but this is my opinion. Did I answer your question?
Thank you, Prof. Partially, but I was asking you, since you're a prof in this field, an expert, do you envision in the future where, so I thank you for that distinction, but do you envision a future situation where from the budget that gets allocated, there just won't be enough to pay claimants, as well as tend to the resources, and what do you think would then happen in a situation?
Well, at some the hospitals in KwaZulu-Natal, they've even taken the people's desks and chairs and blinds at the windows to get money. So the money can dry up. Okay, so that is why the Law Reform Commission have also designed that document that is now out for public comment, because it cannot go on like that. Now there's 2 scenarios. Of course, doctors should stop being so negligent. So you need to invest in the training of doctors and nurses in the public sector to stop them from being negligent. That's one side. The other side is then compulsory mediation in order to curb the cost. And then there's another school of thought that say you must cap the amounts that you can claim. For example, in the road accident fund, you claim a certain amount if you lost an arm. And you can claim a certain amount if you lost a leg or whatever. There's a determination. So at this stage, it is not clear where it will go. There were summits where the minister, when it was still Dr. Aaron Motsoaledi, where they discussed it. Everyone is aware that we cannot go on as it is currently with those huge amounts claimed for medical negligence. But there is another side as well. The public sector must pull up their socks. Why? A problem that I see in the public sector is, okay, the baby, a shortage of oxygen, the baby's born, cerebral palsy, go to court, maybe get 20 million damages. But that same doctor keeps on working. So the whole disciplinary process of doctors and nurses guilty of not treating patients the way they should be stricter. So the HPCSA should be a harsher watchdog and discipline these people or suspend them, that they don't get salary for a year or whatever. But in the public sector, if there was negligence, that same doctor and that same nurses, they just carry on. They just work again tomorrow. And that is not solving the problem. That is not solving the problem. So they need some attention. But to answer you shortly, money is going to run out, definitely. But remember, then there's also now the research for the national health insurance. I don't think there's enough money for that. But the president said it's definitely coming in 2026, maybe because of COVID, it might be 2028. But remember, that will change a lot. I don't know whether it will be for the better or for the worse. But to be quite honest, yes, the money in the public sector for hospitals, nurses, and doctors being negligent can run out, because there's only so much in a budget for a year. Road accident fund is something different, because they get it on a monthly basis, they get an income. But yes, to summarize, the whole situation on medical negligence cannot go on as it currently is. Okay, Tony, old hand, new hand.
That's an old hand, ma'am.
Okay, Bruce, is it an old hand or a new hand?
A new hand, Prof. It just pertains to the course itself. My understanding is that the assessment is the 2 portfolios as well as the test. However, on the program, on the 17th, the week post the 12th, it's stated there are certain things due, about 6 items due, say 12 p.m. on that day. So
isn't that portfolio 2?
No, portfolio 2 is due on the 11th. Then the last due date for the test is the 12th. But on the program, on the 17th, there are 6 items which are itemized, and it also says due. Now, I don't know whether that maybe pertains to a rewrite for some people or a reassessment or not. If they could just clarify.
I don't know, because we don't have rewrites at all. Well, isn't it perhaps that the marks are being released on that day?
Okay, hopefully, I think if it's a problem, I will ask Grace that question, because it's a bit confusing here. Yes, that's right.
Because the only assessment that you go through is test 1, multiple choice, 6 activities, 1, 2, 3 is portfolio 1, 4, 5, 6 is portfolio 2, and we count the marks, and that is all that you are assessed on.
Okay, no, thank you very much, Prof. Thank you very much for
Okay.
everything. I really thoroughly enjoyed these webinars.
Okay, it's a
I-
pleasure. Lesedi, I see your hand.
Thank you, Prof.
Lesedi?
Good evening, colleagues.
Yes.
Allow me to tap on your wisdom on this one, Prof. Can you hear me?
Yes, I can hear you.
Okay, in a situation whereby a sterilization procedure is made on a client, and then the client is informed, this is not 100%, and as time goes on, it will get weak. And then on the final year of the she falls pregnant, and because of for health reasons, the pregnancy is terminated. What claim, if any, can this my client put across before a court of law? And would the fact that they would have told her that it's not 100% constitute any justification in law to defeat the claim that she can make? Thank you, Prof.
It depends. It depends. Okay, what information was she given concerning the sterilization? What kind of sterilization was it? And whether there is some or other proof that the doctor explained to her that there's a risk. If the doctor can prove that he explained to her, she understood, of course he has no case. If he did not explain to her or were not clear, in other words, it is worth trying, but now what damages did she suffer? The only damage may be the trauma and the costs of the abortion. If she had the abortion in the public sector, then of course there's no cost or minor cost. If she suffered trauma, then can she prove that? Did she went to a psychiatric institution or for psychology? My opinion will be it will be very difficult to prove. It will the cost will outweigh the amount that she will be able to claim. But that is my feeling. You
Well
welcome
appreciated.
differ. Yeah.
Much appreciated, and I appreciate so much the heads up. Thanks, Prof. Good evening.
Thank you. Thank you. Is there anyone else? Then you can just speak. Okay, then as I've
Sorry,
said, yes, Anushka.
Sorry, it's Anushka here again. Yes.
Yes,
So
yes.
one, sorry to disturb you. I just have one thing that was concerning me was the age of majority for a child to claim. So from what I understood, you said when the child turns 18, they have 1 year in which to claim. However,
Yes.
I know with the RAF, it's 3 years. So I want to know, why is there such a distinction? Because a child may not necessarily know their rights to claim, and it's quite a short period in which to get hospital records, do the necessary research, and then issue summons. Especially considering the duration that has passed.
Yes, I hear what you say. It will depend. If you read that constitutional court cases, the Loney and the Links one, you will see that they now interpreted it widely. You just indicate, in other words, if the year goes past and you haven't issued summons and they come with prescription, your ducks must just be in a row to say what you have done in that year. And if you say, but I was waiting for this records and records, in other words, if you can prove that you tried to get it done, that will count in your favor. But to be honest, I don't know why there is a discrepancy.
Okay. All right. Thank you, Prof. Basically, we should just have to show reasonable
yes.
reasonable action that we've taken.
Yes. Yes, excellent.
All right. Thank you. Thank you, Prof.
Okay, guys, thank you so much. Then this is the last time you will be seeing me. Good luck with your different careers and what you choose to do. You have my email address. If you have more questions, please do your best with test 1 and portfolio 2. And if you run out of time or whatever, speak to me and Bonnie and we'll see whether we can make a plan. Thank you so much. Have a good evening.
Prof.
Bye-bye.
Bye.